State of Ohio versus Noel Nelson, case number 25CR795. The defendant is present with counsel Greg Roby and will appear today for a sentencing hearing. We were last before you on November 12th, and at that time the defendant pled guilty to count 1, to trafficking in a fentanyl-related compound, a felony of the 4th degree with forfeiture specification, to count 4, trafficking in cocaine, a felony of the 5th degree, and to count 6, trafficking in cocaine, a felony of the 5th degree. During that hearing, a pre-sentence report and drug and alcohol evaluation were ordered. Those reports have since been completed, and the defendant has 7 days of jail time credit.
Mr. Roby, any reason not to go forward with sentencing?
No, sir. We're prepared.
Anything you want to say on behalf of your client?
Yes, Judge. Thank you very much. I would just echo some of the things that I talked about in the sentencing memorandum that I filed. So Noel is before you today. He's 36. He lives in Cleveland. He's got a stable home. He lives with his partner. They have a good relationship. It's a stable relationship. He's got plenty of family present in courtroom today, 3 of his sons. He has custody of 2 of those sons and worked hard to get that done. He does have a stable job working at a cleaning company. He's worked there for over 3 years. It's not glamorous work, but it pays the bills for him. There's no dispute he does have a prior criminal history. By my reading of the records supplied by the government, it looks to me like the last time would have been approximately 2015, 2016 for a felony offense. So it's been almost a decade. I don't think there's any great dispute as far as the facts involved here. After Noel experienced the death of the mother of one of his sons, he started battling and wrestling with depression, fell into using drugs. No dispute as far as the facts. There were 3 separate sales to an informant, small amount of drugs. He'll be the first.
It wasn't a small amount of drugs.
Pardon me?
It wasn't a small amount of drugs.
Relatively small, Judge.
Well, maybe for your cases that you handle it.
I suppose we all
look
at this. Right.
Okay.
I digressed. I would say that he's the first one to admit that he made some poor choices in trying to earn extra money to support his own habit and the burden of now having children under his roof. I think his letter speaks to that. I think he's very plainly and he's honest, says what happened. I would ask the court to consider that he's accepted responsibility without issue. I think there is genuine remorse. I think you're going to hear that from Noel here today. He knows what he did was completely unacceptable. He's never came up with excuses. I would ask the court to consider his family support, the letters, and the people who are here today, his job, his home, his relationship, his family, give him plenty of stability, and those are the tools that I think that he can use to succeed if the court would give him the privilege of community control. And that's what I would request. Thanks.
Thank you. Mr. Nelson, you have the right to address the court before your sentence. You can say anything you'd like. Is there anything you want to say at this time?
Yes, I would like to say that I made bad decisions to put my kids in harm's way, me not being in their life, and I accept whatever that comes with the choices that I make going forward. I just want to do better because my kids need me there, and they all I got. I'm all they got. That's it.
Thank you, sir.
Thank you.
Mr. Roby, anything else on behalf of the defense?
No, sir. Thank you.
Thank you. Ms. Bell for the State of Ohio.
Thank you, Your Honor. The state had the opportunity to review the pre-sentence report in this case, and based on the review of that report and the memorandum filed by Mr. Roby, the state is recommending community control in this case. Thank you.
Thank you. I reviewed the pre-sentence report and investigation. Drug and alcohol evaluation. I have considered the facts and circumstances of the offense involved, the nature of the offense involved. I received and reviewed the sentencing memorandum that was filed by Mr. Roby on behalf of his client, along with the letters in support of the defendant. Now, I've considered everything said here today. All this is considered by the court in light of the purposes and principles of felony sentencing which are set forth in 29-29-11 of the revised code. As for the factors in 29-29-12, nothing stands out factually indicating the conduct is more or less serious than what normally constitutes the commission of these offenses. As for the recidivism factors, the court notes the defendant does have criminal history, which dates back 20 years, starting as a juvenile. Juvenile delinquency adjudications and then becoming an adult. Have continued. Got at least 3 prior felony drug charges, convictions on his record. 2 of them involved trafficking. The latter happening in 2015. Defendant has been on probation before and has violated his probation, so the factor of not complying with previously imposed sanctions by courts is present. Under 29-29-12E, that it does appear to be genuine remorse. Under 29-29-13B1, the court notes, strike that. None of those factors are present. The court finds at this point that prison would not be consistent with the purposes and principles of sentencing despite the defendant's history. But as noted by Mr. Roby, the last offense was 10 years ago, felony offense. There's a couple of, I think, open containers since then, if I'm remembering correctly. And the court finds the defendant is amenable to available community control sanctions. So I'll give you a chance on community control sanctions. I'm going to order that you be placed on community control sanctions for a period of 2 years on each count. Those will be concurrent. I'm going to order, however, that there are some consequences involved here. You're going to be ordered to serve 60 days in the Lake County Jail. You have credit for 7 days you've already served. While in jail, I want you to enter and successfully complete the jail treatment program during the last 30 days. Again, successfully complete that program. Follow all their aftercare recommendations. Further conditions, you're not to use any drugs or alcohol. That includes no marijuana use. To submit random urine screens, they have to be negative. A positive screen is a violation. You can't tamper with urine samples, bring in fake urine, someone else's urine, anything like that. That's actually worse than testing positive in my view. You're to attend 3 AA meetings a week and have a sponsor. Obtain and maintain full-time employment. You're to obtain a mental health evaluation and follow whatever, if any, recommendations are made. If they believe you can benefit from any type of counseling or treatment, medication, whatever the case may be. If there isn't anything, then there isn't anything. But if whatever recommendations are made, you're to follow those recommendations to help you with some of the issues that you discussed, which led you to getting back to where you are here today. But the plan is to get you back to where you were before that, where you were for the last 10 years. So that's the point of all this. You to pay court costs and supervision fees, in order the forfeiture of the contraband and instrumentalities. I'll dismiss counts 2, 3, and 5. Bond will be released if any bond is posted by the defendant. Derek, anything else I should be considering or thinking about?
No, Your Honor, thank you.
So, Mr. Nelson, you understand all the conditions of your community control sanctions?
Yes, Your Honor.
Any questions for me?
No, Your Honor.
I need to advise you that if you fail to comply with any of these conditions, any of the rules of probation, if you leave Ohio without permission from the court, or if you commit another offense while on probation, a motion to terminate your community control sanctions will be filed. And if it's found that you did violate, I could extend your probation up to 5 years, can impose more restrictive sanctions against you, including jail time, or I could terminate your probation and send you to prison. 1 second. And if I sent you to prison, it would be for a term of 18 months on count 1, 12 months on counts 4 and 6. Those would all be served concurrent with each other for an overall prison term of 3.5 years in prison. That could also be consecutive to any other prison sentence you may be serving if there's some other case that occurs or that you're being sentenced to at that time. All right, Ms. Bell, anything else for the record?
Nothing further, Your Honor. Thank you.
Mr. Roby?
No, sir, thank you.
All right, thank you.
afternoon, Your Honor. We are hearing case 25 CR 645, State of Ohio versus Javon S. Graves. Present in court is the defendant, who is accompanied by his attorney, Ms. Rachel Smith. We were previously here on November 13th, 2025. At that time, the defendant withdrew his previously entered plea of not guilty and entered a plea of guilty to count 1, having weapons while under disability, a felony of the 3rd degree with an attached forfeiture specification. The matter was referred to the Lake County Adult Probation Department for a pre-sentence investigation and report, as well as a drug and alcohol evaluation. Those reports have been completed. The state has had an opportunity to review those reports and is ready to proceed with sentencing. The state would move to dismiss the remaining counts of the indictment, and there are 44 days of jail time credit. Thank you, Your Honor.
One second. All right, Ms. Smith, any reason not to go forward with sentencing?
None that I'm aware of, Your Honor.
Anything you'd like to say on behalf of your client?
Your Honor, on behalf of Mr. Graves, Mr. Graves is before this court, 28 years old, and this is his first having weapons under disability offense. Although he does have a prior criminal history, he has no offenses of violence, no offenses in which a gun was used, only carried, and Mr. Graves has never been to prison. Mr. Graves has demonstrated for this court at various points during the pendency of this matter how he would conduct himself as a probationer, and not yet having received the benefits of some of the services available through probation, Mr. Graves was on an OR bond for the pendency of this matter without issue until his change of plea. At his change of plea, he showed complete candor with this court and advised the court that he would test positive, that he had consumed liquor and cocaine within 23 hours of his hearing, both at the stop and the matter at hand, as well as knowing that he had violated his bond. He did not run or flee. One thing that can be said about Mr. Graves is he always shows up, even when he knows he's facing negative consequences for his actions. Mr. Graves was advised at his change of plea exactly what would happen were he to test positive, as he shared with this court he would, knowing that he would be facing arrest at his pre-sentence interview, and knowing that his sentencing date was not until after Christmas. He still showed up. He showed up and was taken into custody as anticipated. He spent 41 days since his pre-sentence interview in the Lake County Jail. Mr. Graves has family present. They've been present for every hearing. They're incredibly supportive. However, they are not enabling. I was present for the conversations between him and his uncle when we were discussing the resolution for this case, and I believe that Mr. Graves has a strong support system that, in addition to the probation department, will help hold him accountable. Mr. Graves does have a cocaine abuse issue and would benefit from treatment for that, and we would ask the court to impose a community control condition that he be assessed and treated for that issue. Thank you.
Thank you. Mr. Graves, you have the right to address the court before your sentence. You can say anything you'd like. Is there anything you want to say at this time?
How you doing? I wanted to say that I'm sorry for all my wrongdoings, and yes, I do need help with cocaine, and if you could give me the chance to show that I can do it and be a better person with probation, I really love that chance, and I do have a strong support group, and I know I've done wrong, and I turn myself in, and I just want to do what's right by me, my family, and the court. So I really appreciate it and be grateful if you can do that for me. Thank you, Your Honor.
Thank you. Ms. Smith, anything else on behalf of the defense?
Nothing to add at this time.
Ms. Himline for the state of Ohio.
Thank you, Your Honor. It is the state's position that the defendant is not a good candidate for community control sanctions. This is his second offense or second conviction for a weapons offense. The defendant has attempted treatment in the past unsuccessfully. He does have a history of probation violations and violated his bond conditions with this court by testing positive for cocaine. For those reasons, the state does recommend that the court impose a sentence of prison in this case. Thank you.
Thank you. This court did review the pre-sentence report and investigation. Excuse me. Drug and alcohol evaluation. I've considered the facts and circumstances of the offense involved, the nature of the offense involved. I've considered what's been said here today by Ms. Smith, the defendant, the prosecutor, the recommendations from all the parties. All this is considered under the purposes and principles of felony sentencing set forth in 29-29-11. So the factors in 29-29-12, nothing stands out factually indicating the conduct is more or less serious than what normally constitutes the commission of this offense. As for the recidivism factors, the court finds the defendant does have a history of criminal convictions. He does have a prior weapons charge before. He may not have a weapons under disability, but he's got a prior felony weapons charge before, in which he was put on probation in Cuyahoga County and violated 6 times. Violated a month after he was first put on probation, a couple months later, a couple months after that, a couple months after that, month after that, a couple months after that. So he's not responded favorably in the past to previously imposed sanctions ordered by courts. There's no genuine remorse in regards to this offense, and when he met with the probation department, that's for certain. Felt like he was being targeted, that this shouldn't have happened, shouldn't have been pulled over, stopped, the gun shouldn't have been found. Violated his bond by drinking the night before his hearing, and also for using cocaine before his hearing. And he used cocaine again, even after you left here. Before you came back for your interview, you used again. No factors indicate recidivism is less likely. This is felony of the 3rd degree. There's no presumptions one way or the other. And considering the history here, the fact that we're back again for a second felony weapons charge, and the last time you had 6 probation violations, and you're back doing this same stuff basically. Court's not unable to make a finding that you're amenable to community control sanctions based on the history here, as well as in this particular case. Therefore, the court also finds prisons consistent with the purposes and principles of sentencing. Therefore, it's the sentence of this court that in count 1, defendant served a term in prison of 12 months. Gets credit for 44 days he's already served. Need to advise you upon your release, you could be placed on, it's not mandatory, but you could be placed on post-release control for up to 2 years. If you are and you're violating any of those conditions, the parole authority can send you back to prison as punishment for violating the rules for another 6 months, the maximum being 50% of the term I just imposed. Any additional prison term imposed for violating post-release control is being imposed as part of the sentence at this time. The court disapproves the defendant's placement in a program of shock incarceration, intensive prison program, or transfer to transitional control. Defendant's awarded the pay all costs. I'll dismiss the balance of the indictment, and any bond is hereby released. Similar, is there anything else for the record?
Just the forfeiture, Your Honor.
Oh, I didn't say that. That must not have. Contraband and instrumentalities set forth in this specification are hereby Any right, title, or interest that defendant has in that property is forfeited in the state of Ohio. Thank you. Smith, anything else?
Not at this time, Your Honor.